Good morning. Your name for the record, counsel?
Aylaian for Justin Aylaian.
And sir?
Good morning, Your Honor. My name is Justin Aylaian.
Thank you. And counsel?
Good morning, Your Honor. Peter Keiko for Justin Aylaian.
Thank you. And counsel?
Good morning, Your Honor. Timothy Bradel on behalf of Kelsey Fitzsimmons.
And ma'am?
Good morning, Your Honor. Kelsey Fitzsimmons.
And counsel?
Good morning, Your Honor. Julie Hess for Kelsey Fitzsimmons.
And in the back, counsel?
Good morning, Your Honor. Ryan Leonard for Kelsey Fitzsimmons.
Thank you. Would the parties please raise their right hand? Do you solemnly swear the testimony you're about to give in the cause now in hearing will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes.
Sir?
Yes.
Thank you. We're here today on what was scheduled as an evidentiary hearing on the underlying abuse prevention order in accordance with General Laws, Chapter 209A, that is pending before the court. The court has been provided by the clerk a joint motion to incorporate a stipulation of the parties regarding the extension of the abuse prevention order. Is that correct, counsel?
Yes, Your Honor.
And from your behalf, counsel?
Yes, Judge.
All
Pleased to report the stipulation.
All right, I've had the opportunity to review the stipulation, and I appreciate the time and effort that counsel put into achieving that. I do have problems with the following language. I'm just going to read the language to you. In paragraph 2, it indicates the parties agree that the 209A abuse prevention order as modified herein shall remain in full force and effect for a finite period of 90 days. Then this is where I'm not comfortable with the following language. And provided that there are no violations of the order during that time, shall automatically expire and be vacated on July 13th, 2026 without the need for a further hearing or review. I'm not comfortable with that language. I would accept that you wish the abuse prevention order to be in effect for a 90-day period, and then I would schedule it for review on the July 13th date if that is actually the 90-day date. I'm just not comfortable with the other language. However, you folks elect to deal with the hearing at that time, that would be fine. But I understand your intention, but I'm just not willing to accept that language. Do counsel wish to confer for a moment?
I think we have it ready for you, Judge, and I think Attorney Hess is going to address that.
All right, because I know that I did receive an amended, so to speak, version, which says, and shall, you use the word in yours, automatically expire and be vacated without the need for further hearing. Is that what you wish to be heard on?
Well, yes, Your Honor. First, with respect to the amendment, we took out the word automatically. Does
Yeah.
Your Honor still have an issue? Okay.
Yes.
So thereafter, my brother counsel and I had conferred already in case Your Honor did have a problem with that language. And my brother and I had agreed that we would modify the language to show the party's intent if Your Honor would accept that.
I take abuse prevention orders very seriously, and given the nature of review each time the matter comes before me, I would not accept any representations as to what the parties intend, because I don't necessarily see that as relevant. So I would be happy to afford you the opportunity to address the matter, but the language that I would accept would I would be putting a period after days, 90 days period. And so then the matter would be, and then the matter will be scheduled for a review on July 13th, 2026. Because I don't like to condition things on hypotheticals, especially in 209As. Do you wish to step back for a moment and
Yes,
consult with your brother and your client? Why don't we just have the parties step back? And we do have, how many conference rooms do we have out there? Do we have all right, so if you could follow the instructions of my court officer, you can each utilize one of the conference rooms, and then I'll give you a call back in about 5 or 10 minutes. Does that work? If you need additional time, let my court officer know. All right, so we will we will continue the matter just for about 5 or 10 minutes so counsel can address the position of the court. All right?
All right, thank you.
All right, you may step back. Thank you. addressing counsel for the plaintiff, what do you have to report regarding any changes to the stipulation after the court provided some input?
Thank you, Your Honor. I conferenced the matter with my sister, and we took the court's comments under consideration, and we've made that particular edit to the stipulation. And both parties have endorsed that.
All right. And counsel, do you wish to add anything?
No, Your Honor.
All right. Very good. These questions will be directed to the parties relative to the stipulation that was filed today and then altered after second call. The court is addressing what we will call the amended stipulation. It is entitled in that fashion, but it was not the first one that was filed, so that's why I'm referring to it in that regard. Do either of the attorneys wish to summarize it, or should the court summarize it? Why don't I have you summarize it, counsel?
Thank you, Your Honor.
All right.
Your Honor, the parties have come to a stipulation which does two things. It extends the restraining order and it amends it. It essentially, Judge, extends it till July 13th, which is a 90-day, I believe that's the 90-day date, calculated properly. And it also amends the restraining order, Your Honor, to essentially be a simple no abuse order. The no contact provisions, anything to do with the child, those have been deleted. And essentially, we're left with a simple, not simple, I apologize, wrong word, simple no abuse order.
All right. Do you wish to add anything to that, counsel?
No, Your Honor, the parties did, other than the fact that the parties did acknowledge that they did not have the 10-day review hearing, and it is both my brother counsel and my understanding and my co-counsel understanding that this is an effort for the parties to try to move forward more collaboratively, and I think this is a good first step, Judge.
All right. And I note that in paragraph 4 of the stipulation, the parties acknowledge that by entering into this stipulation, the defendant is not admitting to or acknowledging or agreeing with any of the allegations in the affidavit that was filed by the plaintiff. Is that correct?
Yes, thank you.
All right, very good. And so we're going to, after the court conducts the colloquy, but before then, I wanted to address one issue. So paragraph 1 will remain, which is the order not to abuse. Paragraph 2 is going to be vacated, which is the contact provision. So in the event that the court accepts the stipulation, there will no longer be any prohibition relative to contact between the parties. Is that correct, counsel?
That's correct, Your Honor.
Counsel?
Yes, Judge.
All right. And then paragraph 3 is going to be removed, which is the order that prohibited the defendant from being in and around the Stowe, Massachusetts residence where the plaintiff had been at the time the order was entered. Is that correct?
Yes, Your Honor.
Is that correct? Right. And then 4A was a prohibition that the defendant could not be in and around the plaintiff's work area, and that is being lifted. Is that correct, counsel?
Yes, Your Honor.
Is that correct, counsel? And then 6, the father, plaintiff, had been granted custody of the minor through paragraph 6, and that's being removed. Is that correct, counsel?
Yes, Your Honor, and I'd like to add that there is a temporary order in place on the 209C case that does reference custody.
All right. And is that your understanding?
Yes, sir.
So while custody is vacated under the 209A order, there's currently a 209C order that provides that father has custody, and the parties are aware of that. Is that correct?
That's correct, Your Honor.
Is that correct? Okay. And then paragraph 7, which prohibited previously contact with the child, that's going to be vacated as well. Is that correct?
That's correct, and likewise, Judge, there is a temporary order in the 209C case that references contact with the child.
Is that your understanding, counsel? Right. And the other provisions remain, including paragraph 12. Is that correct?
Yes, Your Honor.
Is that correct? All right. Do either counsel wish to make any other comments prior to the court conducting the colloquy?
No, Your Honor.
All right, very good. These questions are directed to the parties. You are here today for an evidentiary hearing wherein you would be afforded the opportunity to present evidence, to have witnesses, and to conduct testimony and cross-examination. Are you aware of that, sir?
Yes, Your Honor.
Are you aware of that, ma'am?
Yes, Your Honor.
And this was considered what would be called a 10-day hearing because the 10-day hearing had previously been continued on a number of occasions due to other reasons that the parties had agreed to. Is that your understanding, sir?
Yes, Your Honor.
Ma'am?
Yes, Your Honor.
And based upon that information, both of you are electing to waive the ability to engage in an evidentiary hearing today. Is that your understanding, sir?
Yes, Your Honor.
Ma'am?
Yes, Your Honor.
Did you have enough time to think about that, sir?
Yes, Your Honor.
Ma'am?
Yes, Your Honor.
And did you have sufficient time to communicate with your attorneys about this issue and to have all of your questions answered by your attorney to your satisfaction, sir?
Yes, Your Honor.
Ma'am?
Yes, Your Honor.
And based upon the stipulation that you have provided to the court, certain important issues have been altered, so we'll review those. Paragraph 1 will remain, which indicates that that you, ma'am, will not engage in any abusive behavior toward the plaintiff, Mr. Aylaian. Do you understand that, ma'am?
Yes, Your Honor.
And do you understand that provision, sir?
Yes, Your Honor.
Furthermore, moving on to paragraph 2, wherein previously, ma'am, you were ordered not to contact the plaintiff and to stay 150 yards away from the plaintiff. And sir, you are now requesting that the court remove that provision. Is that correct?
Correct, Your Honor.
And is it your understanding, ma'am, that that provision will be removed?
Yes, Your Honor.
So is it your understanding, sir, that there will no longer be a prohibition for the defendant to contact you? Are you aware of that?
Yes, Your Honor.
Are you aware of that provision, ma'am, and understand it?
Yes, Your Honor.
And you understand it as well, sir, is that correct?
That is correct, Your Honor.
And similarly, paragraph 3, there was an order that the defendant leave and stay away from the address where the plaintiff had previously indicated he was residing. And sir, you are requesting that the court vacate that provision, is that correct?
Yes, Your Honor.
So you're aware that there will no longer be a prohibition for the defendant to come to that location, is that correct?
Yes, Your Honor.
All right. And ma'am, similarly, you understand that there are no longer any provisions relative to you staying away from the residence of the plaintiff. Are you aware of that?
Yes, Your Honor.
All right. And similarly, there was a prohibition, sir, previously that the defendant remain away from your place of employment. Are you aware of that?
Yes, Your Honor.
And you are now asking the court to vacate that position. Is that correct?
Yes, Your Honor.
So you understand that if the court allows the stipulation, there will no longer be a prohibition that the defendant stay away from your place of employment. Do you understand that?
I do, Your Honor.
And similarly, ma'am, do you understand now there is no prohibition relative to you staying away from the plaintiff's place of employment? Are you aware of that?
Yes, Your Honor.
And there is a child that the two of you share. This 209A order had previously provided the plaintiff father with custody, but the court understands, sir, that you are now asking that that provision under the Chapter 209A restraining order only be vacated. Is that correct?
Yes, Your Honor.
And do you understand that, ma'am?
Yes, Your Honor.
But do you also understand, ma'am, that there is another order in this court through another case that provides father with the custody of the child? Are you aware of that?
Yes, Your Honor.
And you're aware of that as well, sir. Is that correct?
Yes, Your Honor.
And similarly, paragraph 7 was a prohibition from defendant contacting the child. And sir, you are now requesting that the court vacate that position. Is that correct?
That is correct.
Is that correct, ma'am?
Yes, Your Honor.
So are you aware, sir, that if the court accepts this stipulation, there will no longer be a no contact provision in effect between the defendant mother and the minor child? Are you aware of that?
That is correct, Your Honor.
And are you aware of that?
Yes, Your Honor.
All right. And the other provisions that remain is paragraph 12 relative to the surrender of any firearms. Are you aware of that, sir?
Yes, Your Honor.
And ma'am, are you aware that there is still in effect the requirement that any firearms that you may have had or have are going to be turned over to the North Andover Police Department. Are you aware of that, ma'am?
Yes, Your Honor.
And that provision remains in effect. Are you aware of that?
Yes, Your Honor.
And I believe that that summarizes the pertinent aspects of the stipulation. Is there anything else you believe needs to be added, counsel, on behalf of the plaintiff?
No, Your Honor.
On behalf of the defendant?
No, Your Honor.
All right. So having had the instructions, these are the following questions that I will ask you. Relative to the stipulation, did you read and understand it, sir?
Yes, Your Honor, I did.
Ma'am?
Yes, Your Honor.
Did you have enough time to think about it, sir?
Yes, Your Honor.
Ma'am?
Yes, Your Honor.
Did you have enough time to think about the changes that were made after the first call? Sir?
Yes, Your Honor.
Ma'am?
Yes, Your Honor.
Did you have sufficient time to communicate with your attorneys and to have all of the questions that you may have had relative to this matter answered to your satisfaction, sir?
Yes, Your Honor.
Ma'am? And did you sign the stipulation freely and voluntarily, sir?
I did, Your Honor.
Ma'am?
Yes, Your Honor.
Very good. Then based upon your testimony and as part of the colloquy, I will accept the stipulation, finding that it is fair and reasonable and free from fraud or coercion, and enter it in as part of the amendment to the restraining order. And I will make that change now. I know that the matter was also scheduled for a review of the 209C, but I'd like to handle that separately, so if you would kindly be seated, I'll complete the paperwork on the 209A order, and then we'll address the 209C. You may remain seated where you are. Thank you. On the Aylaian and Fitzsimmons matter at docket number 25W0966. Good morning again, counsel. Your name for the record?
Good morning, Tyra Cameron for Justin Aylaian.
And sir?
Justin Aylaian.
And counsel?
Peter Keiko, Your Honor, for Justin Aylaian.
Thank you. And counsel?
Julie Hess for Kelsey Fitzsimmons.
And in the back, counsel?
Morning again, Your Honor. Ryan Leonard for Kelsey Fitzsimmons.
And ma'am?
Good morning, Your Honor. Kelsey Fitzsimmons.
And counsel?
Timothy Bradle for Kelsey Fitzsimmons.
Thank you. Once again, the parties have been previously sworn, so their statements remain under oath. The 209C matter was also scheduled for a review hearing today. I understand that next Thursday that there were other motions scheduled. Is that correct, counsel?
That is correct, Judge. There were cross motions for temporary orders.
All right. Is that correct? All right. And one other housekeeping issue, so to speak. The restraining order, which I signed, indicates that the matter will next be heard in the Lawrence session. So I wanted to bring that to your attention because in accordance with the rescheduling, or I suppose redistricting of matters in the Essex County Probate and Family Court, certain cases now based upon the residency of the parties are going to be in Lawrence. We just, I'm going to, so that we don't mix cases up, I'm going to continue with the 209C, but I may need to address one other matter in the 209A with you, okay? So what do you wish to report to me relative to the 209C 25W0966 case, counsel?
Well, Judge, generally speaking, my sister and I did file a joint status memo. Gives the court a procedural history of the case. We have exchanged some discovery that we still both have to clean up. We referenced the motions, and this case was originally scheduled for a pretrial conference on May 1st before Her Honor. In light of the fact that the case is being moved, we've had some conversations with your session clerk, and we understand that the 209C case is also being moved to Lawrence.
Correct.
And we've lined up with the court's great help, a date for the pretrial conference, which I believe is July 15th. And it was also our understanding, Your Honor, that Judge Ulwick had availability on her motion hearing list for April 28th for our motions. Also recognizing that the court was willing to hear our motions on the 23rd, we've agreed to have since the case is going to be moved to Lawrence anyway, we've agreed to have the cross motions for temporary orders heard on the 28th in Lawrence before Judge Ulwick. We have provided the court with a joint motion to procedurally make that clear.
And what date were you seeking to have them heard?
The Madam Clerk gave us a date of March 28th, which we have put into a joint motion. I'm sorry.
April. Okay, because I'm just going to give that back to you because the motion is titled using March. So I'm just going to have you, I think that was just a scrivener's error.
It was absolutely a scrivener's error.
No problem. So the motion now is titled Joint Motion to Move Hearing from date from 4/23 to 4/28. Is that correct? All right. And Judge Ulwick has availability on that date? All right. And so both counsel recognizing that the matter is going to be transferred ultimately to Lawrence want to have the same judge make the underlying temporary order as well as address the matter going forward. Is that correct?
Yes.
Is that correct? All right. I'm going to allow that. All right. So you'll be 10 o'clock on the 28th in Lawrence. All right. And I'm going to add on this motion that all prior orders not inconsistent herewith remain in effect. Is that agreeable to you, counsel?
It is, Your Honor. Thank you.
Is that agreeable to you, counsel? All right. So then we will not need to address any of the other issues in the 209C case. Is that correct, counsel?
That's correct, Judge.
Counsel? All right. So let's just one quick moment look back. I'm just looking at your stipulation. I just want to indicate you didn't, I think that the way we have it is fine. It just says the parties agree the abuse prevention order as modified herein shall remain in full force and effect for a period of 90 days. And we have the 15th of July. Is that the 90-day date, or is that the date that Judge Ulwick can hear the matter? So do you folks want to do that so that I'm trying to avoid you having to come into court on multiple times. So you're scheduled for April 28th for motions in the 209C. I think we acknowledge that,
Yes.
Correct? And then in the 209A, you had asked for a 90-day date. However, because the matter is being transferred to Lawrence, the date for the pretrial is July 15th. And I was going to continue the restraining order to that date so that you didn't have to come in on the 13th and then on the 15th. So is that agreeable to you, counsel?
It is.
Is that agreeable to you, counsel?
It is, Your Honor. It's just that, you can imagine the gravity of a no abuse order for anyone and everyone involved. If the court is agreeable, I would prefer to leave on the 13th date, and it also coincides with the 90 days that we put in the stipulation.
Because right, but the reason why I asked is because, let me just see, because you crossed that whole thing out.
Well,
Do you see what I mean? I'm just wondering where, we can leave it with the 90 days and then just have it be the 13th if you want to do
I
that.
prefer to do that,
Okay.
Your Honor, and the 13th is certainly already on the restraining order, is my understanding, right, is the return date.
Yep, I mean, we can easily do it that way.
Thank you
All right.
for asking, Judge.
All right, so I'm going to indicate that the restraining order will be on review for the 13th, as was requested in the order, in the stipulation, even though it was crossed out. It says the 90-day period, so I think that in and of itself is clear.
Yes, thank you.
Do you understand that,
I do,
counsel?
Judge. That's fine.
And you understand that? Okay, very good. I just want to make sure. Yes.
The 209C is also being transferred to Lawrence, so that's where we're supposed to be on the 13th, is that correct?
Correct. All of the matters now will go together to Lawrence. So your dates for hearing will be as follows. The motions will be addressed on April 28th at 10 a.m. in Lawrence before Judge Ulwick. the abuse prevention order will be heard on July 13th at, should we do that at 9 or 10? All right, at 10 a.m. in Lawrence. And then the pretrial will also be heard in front of Judge Alwick in Lawrence on the 15th of July, and that notice and order has already been prepared. All right? So I think that clarifies. Let me just double check all of the documents here. So we will send out to you in the mail the documentation relative to the 209C, and I'm going to provide the, are we going to have Deb upstairs? Okay, she's up, okay. And our 209A clerk, I'm going to give the 209A order to her, and then the parties can cooperate with her following the instructions of my court officer to have those matters served. Madam Court Officer, could you kindly provide that to our 209A clerk? So I believe that that concludes all of the matters before the court today. Is that correct, counsel, for the plaintiff? Plaintiff, counsel for the defendant? Very good, thank you. You may step back, and we will get these others out to you in the mail promptly. Thank you very much.
Thank you, Judge.
You're welcome.